Welcome to In the Name of the Law, with your host Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Amy Bailey from Bailey and Terranova Attorneys at Law, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real people with real legal problems. Today's episode, we're going to talk about the rights of grandparents to see their grandkids. We're going to talk about how federal criminal cases are different from state court criminal cases, and also the rights of motorcycle accident victims and how that's different than auto accidents.
In the name of personal injury law.
Welcome back to In the Name of the Law. Today we're going to talk about motorcycle accidents, and I'm here with Steve Sinas of the Sinas Dramis Law Firm. Now, I understand that a motorcyclist who is involved in an accident has rights that may be different than a regular auto crash. Can you tell us about that, Steve?
Yeah, so I've had the privilege to represent many people who have been unfortunately injured in a motorcycle accident. And most people understand that motorcyclists have different rights than people who are injured in auto accidents. Some of the rights may be similar, but there are certainly differences. So let me first start talking about medical expenses. So what motorcyclists need to understand is that if they're in a crash, the general rule is they don't have a right to turn to auto no-fault insurance to pay their medical expenses. That's the general rule. However, if their crash somehow involved a motor vehicle, meaning that the motor vehicle hit them or somehow caused them to crash, they may be entitled to no-fault benefits. I'm actually litigating a case currently that deals with the issue of whether bright lights on a car could constitute the involvement of a motor vehicle so as to give my client the right to no-fault benefits. And that's actually an uncertain area of the law right now. So there's this test that motorcyclists need to understand that needs to be analyzed, and it can make this huge difference to open the door to have that lifetime coverage that's currently available under the no-fault law. And so it's a big issue that has to be looked at in motorcycle crashes. If you can't show the involvement of a motor vehicle, then you have no right to no-fault benefits. Then you need to turn to private health insurance, or if you're on Medicare or Medicaid, whatever it may be, you're not going to be able to get no-fault insurance to pay for anything, so you're going to have to find another source of coverage.
Are there other no-fault benefits aside from medical benefits that for a motorcyclist who's involved in an accident?
So if it's determined that a motorcyclist's crash involved a motor vehicle, they have a right to no-fault benefits that includes medical, and it also includes 3 years of wage loss, which is 85% of their gross income, and it's up to a monthly cap. Right now it's about $5,600, give or take. It changes every fall. And right now, the wage loss benefit is for 3 years, and so if you're injured in a crash and you have no-fault benefits, you have medical expenses, wage loss, and then there's this household chore benefit, which is part of the no-fault benefits. It's called replacement services, $20 a day for 3 years. Not a big deal, but it helps the motorcyclists with their chores around the house they might not be able to do because of their injuries.
Is there a way that a motorcyclist would be disqualified from having the no-fault benefits?
Yeah, so this is a little hard for people to understand, but you may be found to be entitled to benefits because the crash involved a motor vehicle, but there could be other reasons why you get disqualified. And here are some of those reasons. One, you're driving a motorcycle or operating a motorcycle that has been stolen. So if that's the case, then you could be disqualified. The other way is if you have been listed as an excluded operator on the insurance policy that may cover that motorcycle. But then the one I see the most often is the uninsured motorcyclist disqualification, where if they didn't have liability and property protection insurance on their motorcycle, which they're required to have under the law. In other words, they were uninsured, they didn't meet their insurance obligations under the law. The no-fault law says even if you are entitled to no-fault benefits, you're disqualified because your motorcycle didn't have the required insurance.
So for me, it just seems a little bit of common sense that if you're in a motorcycle accident as a motorcyclist, your injuries are maybe a lot worse than the automobile that's in the accident. Wouldn't all motorcyclists want to have this coverage?
Well, here's the thing to tie it all together. You are entitled to this coverage, this no-fault coverage, only if a motor vehicle is involved. And here's the other weird thing about the way the law works. If a motorcyclist is in a crash that has a motor vehicle involved, the motorcyclist doesn't turn to their own auto insurance. They turn to the insurance policy of the vehicle involved. So say you were driving the motor vehicle and I was on a motorcycle. Whether you caused the crash or not, maybe it was even my fault, But if your car was involved, I turn to your no-fault insurance company and they pay my benefits. And here's the way the new law affects everything I'm saying today. It doesn't really directly affect it, but it has this big impact on the law. People will be able to, as of July 1st, 2020, buy limited no-fault insurance policies. So say you bought a $250,000 no-fault insurance policy, and say I had lifetime no-fault. If I'm on my bike and you are in your motor vehicle, your vehicle's involved, I'm going to have to turn to your no-fault policy, not mine. And if you have $250,000 of coverage, I can't access the lifetime I bought for my auto injuries. And I'm just stuck with your $250,000. So the new law has this effect of making the motorcyclist be at the fate of what insurance choices the vehicle involved, the operator of that vehicle involved made when buying insurance. And that's kind of unfair.
And what rights does a motorcyclist have to sue an at-fault driver?
Okay, so the way the no-fault law works, you get your medical expenses from no-fault, assuming you can get it. And if that's the case, then you have a claim against the at-fault driver for pain and suffering damages and any wage loss beyond that 3-year period that no-fault covers. So your rights are pretty similar to the person who's just injured in an auto crash. You have to prove the same issues and all that. I will say this, though. That disqualification issue I mentioned on the no-fault side of things, if you are an uninsured motorcycle, you can still pursue pain and suffering damages from the at-fault driver, even though you're disqualified from no-fault. So it's a little confusing, right? You can be disqualified from no-fault, but then still have the right to claim these tort damages for pain and suffering from the at-fault driver. That's just a function of the weird language that's in the statute.
So for a Michigan consumer who's driving an automobile, isn't that an incentive for us to have better insurance policies? Because otherwise, if we somehow are involved with an accident with a motorcycle and they're badly injured, our insurance is there to protect us from that situation too.
Yes, I mean, going forward, especially under the new reforms, everybody should have more liability insurance because they can be sued for more. So I think everybody should understand that that's just the reality they face. And with motorcyclists, the reality is that because of the nature of a motorcycle, if they're in a crash, their body is usually seriously injured because there's not much protecting it. So if you caused a motorcyclist to crash, you could be facing a huge amount of liability, especially once these new laws go into effect on July 1st, 2020.
So it sounds like with the new law especially that motorcycles have a lot to think about regarding what kind of coverage to buy.
They have a lot to think about, but unfortunately the laws also set them up for some unfair results no matter what their choices are. And I don't know what to say about that other than that's just the reality that motorcyclists face. Hopefully the legislature can maybe make it more fair for motorcyclists going forward.
Thank you, Steve, for helping us out here.
Thanks.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm. In the Name of Family Law.
We are back with In the Name of the Law with Erica Terranova from Bailey and Terranova, and today we're going to talk about grandparenting time. Now, Eric and I have both represented parents and grandparents in various cases over the years in grandparenting time disputes. So Erica, can you tell us a little bit about how a grandparent would go about getting grandparenting time in Michigan?
And that is true, Lisa. We have both had a handful of cases involving these types of situations. There's a specific statute that lays out when a grandparent has standing. So it's not enough for a grandparent just to say, I'd like to see my grandchildren more often. The courts would probably be flooded with cases if every grandparent were permitted to do that. There are certain circumstances such as the grandparent, their child has passed away, so they can get standing that way. And otherwise, if there's a divorce action, they can enter into that case asking for grandparenting time. There's also, they are permitted if they've provided an established custodial environment for the children, meaning that they've had them living in their home the year prior to filing. So those are just some of the circumstances. The statute is pretty specific, Lisa, so it's always best for grandparents that are thinking of filing this type of motion to speak to an attorney because it is very, there are very strict rules on who can petition the court.
Well, and really importantly, I think, is the people who, the cases where a grandparent is not allowed to ask for grandparenting time, such as when two parents are married to each other, right?
Correct.
And also when a child's already been placed for adoption, even if the adoption hasn't been finalized. So, like you said, the anybody, grandparent that wants to look into this really needs to talk to an attorney to make sure they can get into the courthouse door, right?
Absolutely.
So let's talk a little bit about the process. Once a grandparent has standing to go to court and ask for grandparenting time, what happens next?
The court will hold a hearing at some point. Some courts are referring the matter to friend of the court, just as it would be any parenting time dispute, and trying to resolve it that way. Other courts are going directly before the judge, and there is an evidentiary hearing, or there should be, as to if it's in the child's best interest to have time with the grandparents. If a party opposes it, it's on the grandparents to show that not seeing the grandchildren would cause a substantial risk of harm to the children.
So isn't the deference given to the parents' choice to say, hey, I don't want to have court-ordered grandparenting time?
Absolutely. The courts still look to the parents. It's their fundamental right as parents to parent their children and make decisions who their children are around or spend time with. So they are going to look to the parents and find out, why is it that you do not want grandparenting time? Those are the types of cases that are before the court, because most parents hopefully can work out time that the children spend with the grandparents. But of course, that doesn't always happen, and that's when they need to go to the court to figure it out.
So let's talk a little bit about some examples of what might happen in a case for a grandparent asking for grandparenting time. Do you have any examples to share with us?
Oh, I have a couple examples. I've had some cases where the courts in the end almost treat the grandparents as the non-custodial parent, and they are getting a significant amount of time with their grandchildren. In those cases, I'm finding that there's a long history of contact with the grandchildren. There's already been some sort of informal schedule, and then the court essentially will adopt that schedule because they believe it's best for the children to see the grandparents. I have found a trend in that grandparenting time is increasing. So when I first started doing these cases, I found the courts very reluctant to give much time to the grandparents, because they still did look at the parent and say, you have the choice on how often the children see the grandparents. So I am seeing more time permitted, but it really shouldn't be a custodial determination. It really is how much time should they get with the grandparents.
And what about if two parents agree, even if they're divorced or haven't been married, if they agree that they don't want the grandparents to interfere in the children's lives, what happens then?
At that point, if there are two fit parents that say to the court and sign affidavits and say, we don't want our children to be exposed or have time with this grandparent, there's a presumption, and the court will then either dismiss the case, and there's some situations where it's just one parent might be disputing it, then the grandparents would then have a very high burden to then prove that the substantial risk of harm will be on the child. So again, if you have two parents that are saying we don't want this grandparent to be involved, the court will defer to them, and they are supposed to dismiss the case.
So you've mentioned a couple times the substantial risk of harm presumption that's in favor of the parent, that the grandparent has to show that there will be a substantial risk of harm to the child by denying grandparenting time. Well, what does it take to prove that?
Well, that can be very difficult to prove. Sometimes the facts are just enough that you would hope that the court would find, well, if this child has been living with this grandparent for the last 3 years and then the parent just up and moves that child away, it would be inherent that that would affect the child's mental well-being, and you can show that through school records. But most of the times you're going to have to get a psychologist involved to show that this child will suffer harm by not having time with their grandparents that they were accustomed to have. So I really believe having a mental health or medical professional involved is the best way to prove your case that there is substantial harm.
Having represented both sides of the process, we think in general grandparenting time is good, but can you give us some examples of why parents would say no to grandparenting time?
Sure. It's mainly in the cases where it's the mother or father and it's their ex-partner's parents that may have standing because that ex-partner has passed away or is incapacitated or incarcerated or some reason that they're not around. I find that they may believe that those grandparents are not the best role models for the children or shouldn't be involved because they are not acting in their best interest. Right. So those are kind of some of the examples I'm seeing.
And I think what I've seen is that parents are willing to have for the grandparents to have a relationship with the children, but they don't want it to be ordered by a court and have to have a schedule that's set in stone, and that if they don't follow it, they're going to be in violation of a court order.
That is correct. If you are in a situation where a parent is working out time with the grandparent and there's no court order, but they're allowing the child to see the grandparent really can't come to court and say, I want this to be part of the order, because that parent is, in their own discretion, allowing the time. So there are certainly, it's always best if they can work out something on their own. They're grandparents, it's important to have them in their lives, but we also have to respect parents' decisions. Grandparents are grandparents, not parents.
Thank you, Erica, so much.
Thank you.
In the Name of Family Law is brought to you by Bailey and Terranova Attorneys at Law. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Criminal Defense.
Today we're going to talk about federal criminal cases, and I have Mary and Takura here from Chartier Nyamfukudza. Mary, there's a lot of federal government cases in the news, like Felicity Huffman pleading guilty to the college admissions scandal, or Roger Stone being convicted on multiple counts. So does your firm do federal criminal cases and federal trials?
We do. We do a significant amount of federal work. We have for years. We've had a lot of federal trials. So we always watch those cases in the news pretty closely.
And are federal cases the same as state court cases?
No, they're super different, as you can tell by Takura's reaction. No. There are so many differences between the two. You can't just take, for example, someone who does a lot of state trial litigation, put them in federal court and think that the rules are the same.
Well, what are some of the differences?
One of the biggest differences is a witness list. You get it in state court. What about in federal court?
Absolutely not. A lot of times, the first time you know that Larry Lawless is coming up to the stand is when the government calls them and they're walking up. And a few times, our client is sitting between us and you want to take him? I'll take him.
Right.
Just like that.
A lot of times you'll have a good idea of some of the witnesses, but certainly not all. And then a lot of times the phrase is jumping on the case. So someone might be in the jail. They know, for example, that our client, John Smith, is going to trial. They want to jump on that case because then they're able to get a sentence reduction if the case goes to trial and they were beneficial. So all of a sudden they'll pop up and say, hey, I've got evidence against your client. And then you see this person jump on the witness stand and it's a big surprise to everybody.
So do as many federal court cases go to trial as in the state court? Is there a difference there?
We have a lot of federal cases that go to trial, as well as a lot of state court cases that go to trial. We have a lot of capital cases, and so that's cases where the sentence is life or close to life for the client. In that regard, most of those cases will likely go to trial because the hope is maybe you can sway a jury or maybe you can elicit facts that make those sentencing guidelines less than what they would normally be.
So what are you saying, like if it's a capital case in the federal system, you're pretty much incentivized to go to trial because what is there to possibly lose?
Generally, right. So when you look at the statistics for federal trials, a lot of times and you see, oh my gosh, most of them plead, and that's true. And then you look at the government success rate, and then you think, boy, do you have a chance in federal court? A lot of times you do. Because people, for example, we had a client who was in the life guideline range, and they offered him life, right? Well, why wouldn't you take that case to trial, right? I mean, it'd be ridiculous if you didn't. There would be no benefit to him in our situation not to take the case to trial. And by going to trial, we were able to elicit quite a few facts that impacted the guidelines. So he's going to do about 10 years as opposed to a life sentence.
So he did better than the offer, basically.
Absolutely.
And one of the major differences between state and federal trials is the penalty, right? You won't hear an AUSA call it a trial penalty, but acceptance of responsibility, you get points taken off. Because otherwise, not to make light of it, but these judges give time away like it's Skittles, right? So a lot of times it's a cost-benefit analysis. Boy, do I really want to risk going to trial and losing, or can I control this by accepting this plea and knowing that my guidelines will fall somewhere lower than if I go to trial?
So what about fighting the government? comparing state court cases with the state government, with the resources that the federal government has versus the state government, what kind of differences does that bring about in your cases?
The federal government has tremendous resources. I mean, they dwarf anything on the state end. So they throw everything at a case when they're going to trial. Another very big difference between state and federal court is discovery. In state court, you're entitled to discovery, and things have to happen within a certain number of weeks after you filed your appearance and your discovery demand. In federal court, you're not entitled to witness statements, and that's under the Jenks Act, Jenks, until after that witness testifies. So if you are testifying, let's say you've provided the government information against Takura in a bank robbery, and they've got your statement, you went to the grand jury, we're not entitled to that in 99.9% of the cases until after the government has called you as a witness at trial. And usually, they'll give you the Jenks Act material before trial. Sometimes it might be a day or two. Sometimes, if you're lucky, a week before. But you might get just like thousands and thousands and thousands of pages or thousands and thousands of documents 48 hours before trial. And you have to go through it and try and get ready for trial. It's a big difference.
Right. And if I may add, excuse me, very quickly, another thing is a lot of the federal agencies would deputize, right, local police departments, police officers. So, Officer Friendly from LPD, we deputize you. You are now a DEA agent. So that's another reason that they have so many resources in addition to their own organic.
So you mentioned the witness statements that you don't get until after the person's on the stand. You also mentioned earlier that the government doesn't have to give you a witness list. So my question is that constitutional? Doesn't that violate due process?
You would think it would, right? And many people have tried and brought that challenge, and courts routinely say, no, the statute is acceptable and it's lawful. I personally don't understand how it could be constitutional. I mean, it's no joke. When I say that you get thousands and thousands of pages right before trial, you do. Knowing that, as experienced federal litigators, we have to kind of clear that schedule in the office. So it really becomes all hands on deck, knowing that we're going to be getting this material, and then somebody's got to print it, we've got to index it, we've got to summarize it, we've got to just go through it really, really quickly. It's one of the biggest differences, and you hear some people call it trial by ambush, and it is. I mean, it's crazy that the government has all this knowledge, yet they refuse to turn it over to the defense. But it happens routinely in the vast majority of cases.
Wow. So if someone is tried in federal court for a crime, does that mean they can't be accused or tried for that crime in state court?
No. So double jeopardy doesn't apply to that. They're different sovereigns. There have been cases that have been making their way up to the United States Supreme Court. There was a case that we thought the court would really take a look at it very closely, and they didn't. So if someone has for example, a drug offense that can fall under both state and federal laws as being a violation of, they can be tried in state court and they can be tried in federal court. Those sentences can be served consecutively, meaning one on top of the other. Frequently what happens is the feds will take it over and the state will dismiss their case because a lot of state court prosecutors want to maintain that good relationship with the federal government, but not always. Again, the majority of times when the feds pick it up, the state dismisses, but not in every case.
And you mentioned earlier about sentences being different. What's a basketball score sentence? I've heard that term.
So sentences are ordered in terms of months, right? So instead of 3 to 5 years, it'll be 36 to 60, and it's not unusual, I think, for experienced federal litigators to see 180 and to hear people say 180 to 260. Oh, that's not that bad. So just extremely high, the range that somebody.
Right,
exactly
they're very
right.
high scores.
Right.
Clients who, if we were in state court, may get no jail time, no prison time, and probation in federal court may have a 10-year mandatory minimum based on either the amount of drugs or if they're classified as a career offender. The sentences are very high, and a lot of people don't realize that.
Right. So one last quick question. Michigan does not have the death penalty. Does that mean that you cannot get the death penalty for a federal case if you're tried in Michigan?
No, you can, because the federal courts do, unfortunately, allow for the death penalty. So even if it happens in Michigan, they can get the death penalty. If you're interested in learning more about this topic or other criminal defense topics, check out our podcast, Constitutional Defenders. It is on cndefenders.com or on any other platform where podcasts are hosted. Thanks, Lisa.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC.
Well, we had some very diverse topics today, but I did see a commonality about how there's different rights for who you are in the system. For example, with Amy, and how parents' rights are different than grandparents, or how motorcyclists have different rights than automobile drivers, and how federal cases are different than state court cases. There's a lot of differences there. Steve, did you have something?
Yeah, well, my experience as a lawyer is that people want their lawyer to tell them what the law is, but they don't understand that maybe the law is much different for them compared to someone else just based on their circumstances. And so, my situation with motorcyclists is I get them in and I talk to them. I say, hey, you didn't know this, but the rights you heard about your friend and the auto accident, you got some different rights, so we got to talk about that. And so it's just a matter of having clients understand that it's not always simple, and that based on their circumstances, their rights could be really different.
It's usually not simple.
Yeah, it's usually not simple is right, yeah.
And as we talked about with grandparents, that's a changing dynamic in family relationships, that more and more we see grandparents that are becoming involved in raising children. However, there's certain loops that they have to jump through to be able to attain that status. And the courts obviously want what's best for these children.
Yeah, and again, the easy analogy is David versus Goliath. And in many ways, for example, a jury of one's peers isn't in the actual courtroom what it may appear to be on paper. So yeah, absolutely different.
And when you're dealing with a defendant who's in federal court versus state court, they got a whole different process and situation before them, right?
Vastly different.
Whole different set of risks.
Yeah.
Yes, absolutely.
Right.
Yes. Time is given away like Skittles in those federal courtrooms.
Yes.
100 for you and so on. Yes.
Yeah.
So, and I guess it's important to understand that it's, these aren't simple answers, and it's not simple for the attorneys either. Like, attorneys have to keep up with the law and to understand how these different, how their cases are different, and the law is always changing
It
on
always
us.
is.
We're then, we'll get a new case out, we have to go learn it and make sure we're applying it when we go to court.
And
Or there's a whole new statutory scheme, like with no fault law.
And our clients, would rather not hear about the nuances of case law and all that, but sometimes we have no other choice but to tell them about it because it directly affects their case.
Right.
Indeed. And again, different sovereigns, but yes, much different. And not everyone who practices in state court should practice in federal. So yes, absolutely, different risks and so on.
Well, and a lot of, I think, your clients, they're facing cases in two different forms at the same time. They have a
That's
state
right.
court case and a federal case at the same time that they're having to battle in two different venues with
correct.
two different prosecutors. And it's filled with risks no matter which way you look.
Landmines everywhere.
Right, landmines
Yes.
everywhere.
And in a custody dispute, you have grandparents who love the grandchildren, want to be a part of their lives, but their rights are totally different than the parents. And
That's
just because
right.
they love them doesn't mean they get the rights to see them.
And the courts usually defer to the parents
Yeah.
Right.
if they're healthy.
Well, thank you so much to all of you for this episode today. It was really interesting and informative.
Thank you.
Thank you.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.